Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications, exercise number 5 and 6 on the speed of 90 words per minute. Start. The opposite party filed the written statement denying the allegations, contending that after getting married they lived separately and did not live with his parents. The allegation of demand of dowry was denied, and the incident dated 24th March 2006 was also denied in the manner in which the appellant had alleged. According to the opposite party, the appellant went to her parents' place during Holy Festival where she was pressurized not to go back to her husband's place, and when pressure was exerted, she consumed poison. The opposite party contended that when he was informed, he rushed and took the appellant to the hospital and got her admitted and took steps for her treatment, but after 2 days the parents of the appellant took her away from the hospital while the opposite party had gone out to purchase medicines. In this regard, the opposite party sent a telegram to the SSP. It was also stated that during the course of mediation, the appellant's parents, in connivance with the police, forced the opposite party to consume poison at the police station, as a result of which he was hospitalized and that the police lodged a first information report against him. It was also contended that the opposite party made efforts to bring the appellant back to his house, and when all efforts failed, he filed an application under Section 9 of the Hindu Marriage Act for restitution of conjugal rights. As a counterblast, the appellant filed the suit for divorce under Section 13 of the Act. The trial court, after sifting through the evidence, allowed the application for restitution of conjugal rights and directed the appellant to live with her husband and perform her marital obligations. By another order, the trial court dismissed the suit for divorce. The appellant, being aggrieved by the aforesaid two orders, has filed two separate appeals which have been clubbed together and are being decided. The trial court held that the parties had a love marriage and that they got married after running away from their parental home, and that the parents were not involved, and therefore the question of demand of dowry from the side of the husband's parents did not arise. The court below disbelieved the theory of dowry as raised by the appellant, contending that if the opposite party had raised a demand of dowry immediately after the marriage, in which case the marriage would not have been registered. The trial court further found that after marriage, the couple were living separately and that the appellant was not living with her in laws, inasmuch as the appellant could not remember the size of the room or the effects inside the room where she was staying, nor could she remember or recognize her sister in law and other members of her husband's family. The trial court held that the appellant could not prove that she was living with her in laws. The trial court also held that the divorce suit was filed after the application filed under Section 9 of the Act for Restitution of Conjugal Rights. The contention of Shree Ramesh Pandey, learned counsel for petitioner, is that having studied in the school for last 13 years and having secured about 89% marks in standard 10, there was no justifiable reason for the school for not granting admission to the petitioner in class 11. Not taking admission of the petitioner in standard 11 is an act of high handedness and arbitrariness. The father of the petitioner approached the district magistrate, who ordered an inquiry into the matter, wherein it was found that the principal had acted in a high handed and arbitrary manner. Therefore, an explanation was called from the school and directions were also issued to admit the student, but the principal of the school had adopted an intransigent attitude and declined to admit the student, citing the minority status of the school and stating that admission to standard 11 was not a matter of automatic promotion and it was the discretion of the principal to admit or deny admission to a student in standard 11, which according to petitioner was arbitrary in nature and hit by article 14 of the constitution. The direction of district authorities had also been ignored by the principal. Sri Jaideep Narayan Mathur, learned senior advocate appearing for opposite parties 8 and 9, submitted that the school was a private minority unaided institution. The admissions up to standard 10 were as a matter of right as they were in the nature of promotion from lower standard to the higher standard. As far as the admission to standard 11 was concerned, it was not as a matter of right as it was not a promotion but was a fresh admission, and fresh admission forms were required to be submitted. While taking a decision regarding admission in Standard 11, the principal of the school undertook a consultative process with the teachers wherein the conduct, behavior, and assessment of record of the student as also their guardians was considered. In the case of the petitioner, it was found that the teachers were unwilling, rather adamant, not to have to do anything with the father of the student who had been causing enormous problem not on one or two occasions but regularly. He had problems with the ethos of the college and was not able to come to terms with it. He did not want his ward to participate in extracurricular activities which were necessary for the overall development of the student. Learned Counsel also submitted that it was not the petitioner alone but several students who had passed Standard 10 from the institution and had been studying for long who had been denied admission to Standard 11. One of the students had secured 97% marks, yet he was denied admission.